Maneva na sema PENDREAM TV. PENDREAM TV de osia dem yopo.
Now let's come to a year. What happened in court the day a year Apia Kubi? The day a year ding Apia Kubi call court. Eko kachre a year judge and say a year ding on ye lawyer to ding. Chairman Wontumi biom. Now, you see this. Right now, you know the abetted say ochina attaching say oko in court. Didn't know court or pray for 6 weeks. 6 weeks in any day, or see a free be witness written submission or written addresses. Those submissions, no, you di asem we are lawyer bia odi a client anymore. You will share your opinion on asem na utinemu a lawyer for somebody, no. The accused lawyer etnim etro and I said the prosecution lawyer no. Now judge no really a year appear could be case no that day no because that day na appear could be called court so oko catch court to say on your lawyer to chairman Wontumi bi no judge ni tie ni nsem nyina no na appear could be argument nyina say judge no emptwentwen so because we yi no free say on your chairman Wontumi lawyer bi no Chairman Wontumi kofa another lawyer until my judge and find the judgment in ba. And it's not appear could be called court that time. So the reason why appear could be called court, no, none in Yana say, or catch a judge say, me Chairman Wontumi lawyer, even though wash a date out of judgment in bano, me make appear could be person or change or judgment in so because mean and yamina maybe a written submission no media may call obi neba betro. The question here is then a judge in the car that day na appear kubi eba court beka say on your lawyer to chairman Wontumi biom. Now in fact, because on your loyalty written submission no judge remember from the judgment in ba. Now because any on a better written submission or address that say lawyer for bar which is attaching on the better. But the question here is the written address and not submission from the lawyer after the case has ended. Not judge actually judgment, you know, does it really affect the case? In law, normal law, judge it's not kunduma. So the phone we ba, and no, and a judge no esho hon edi buana asem. Say what the pen we ba, and no, and a judge no esho hon. Say accuse no the pen we ba, no ka say any evidence and no a judge no she. The judge is just looking at the pen. Now say accuse no ed we ba, no ka say we me evidence that the judge is just looking at this. Lawyer Simeonu a omudi accused. And also, whatever, lawyers are more the accused lawyer and our prosecution, their homogene ever assembly, their personal opinion, which is the written address, at the end of the day, is it an evidence a bit me affect the case, nana? And is that two teams, Abo and Ra. Croatia, Asha Ghana 2-1. Now, two teams, field in the Super Bowl. Your FIFA or manage the whole event. There's a referee in the middle of the game. Two assistant referees. They are match commissioners. Ball na ye no pitch this no. There are rules. Now, your ball ni wie. Ebia Ghana ne England the boy and Obian Shibi 0-0, right? There were some nyomebia a see or pitch and so. England goalkeeper na free in the boxing ebe tackles. On a normal day, FIFA rules, any game rules are a red card. The keeper left the demarcated zone also Odini Juma stepping out, whether he touched somebody or touch a ball cry at the end of the day, you look at another red card. So or to make a ball cry out of his box. Now and only who coins also question or tackle be no be tough for man. That ref keeper no so then sakabo, nipa red card. That's how it is. Now Ghana saying another chance. Now omokoshe na in the box a defender a clamp Ghana a player down. Now we now ball no because he needs to defend. He needs to clear that ball. So then I can ball no. Now the player who is attacking goes down in the box. It's a penalty. That's how the rules are. Now so nyama when you see your pitch so referee name, assistant referee so commissioner so yen you FIFA president put to now you referee no bar aben mu say 0-0. whatever the coaches say at the press conference does not change the final score. After game, the coaches can meet the press 50 times. Whatever England coach after the game, after the 90 minutes, plus other time, after the game, what matter? They see your pitch, their time within that 90 minutes and time added on. So 90 minutes, that is what the FIFA regulations recognizes. So Ghana coach press conference 50, and then he speaks about how he's disappointed in the referee. Now it will not change the goal line, the goal scores, the score line. It will not change the point build up. So England coach press conference 50. Now say Ghana coach journalists for Shannon can say, "Oh, Mr. Coach, how did you see the whole game?" His opinion about the game, how his team played, how the opponents played, the tactics he played, how the opponent. It does not affect the final outcome of the game, because the final outcome, the coach's ideas and opinions does not matter. The final, what matters is referee decision take here and the score line at the end of the day and the point everybody got. Our coach can express his views, and in law, the Atachia is a coach. Now, in the middle of the game, FIFA him say, Brony when a coach. Now your ball game na mani bedu 88 minutes. Now Brony nika se niyemi ne ya. Now se o free pitch na suko fie. Now se another technical person ebe som se on a coach. That person's opinion on that game. Say your pawn game na. Sa coach no be take over from Ghana coach no. So in a press conference on to me say, I don't want to accept the outcome of the game because I took over from our coach who wasn't feeling well at the 78th minute. It does not work like that. So, sa coach no beji baton free the sick coach wana obey coaching for the next 12 minutes or 22 minutes. The issue here is FIFA does not care. The referee does not care. What the referee cares about is the game has been played. It's your point game, Now your coach now obesomu from the 72nd minute, see the 90th minute. Eka say he feels that he was not in charge of the game from day one, and so FIFA should reverse the points build up. FIFA should reverse the game for us to replay the game, because time again they starting on the Gina touchline. That is what Atachia is creating here. FIFA recognized the game that was started under the first coach. FIFA recognizes that Ghana had 11 players on the pitch. FIFA recognizes that there were referees refereeing the game. There were match commissioners. Whether you want to change your coach at the bench or not, it does not affect what FIFA, that 90 minutes, he has basically put together. Now Atachia is saying, Onona ebe take over from Apia Kubi at the 87th minute. Now 4 minutes. Yeah, the other timeokrabe count. Emma obedru ya no krampo no na 90 minutes ni abowie. Emma referee the 3 added minutes account. Now see, because oba na yabo 90 minutes na wie no 3 other times so ono Atachia on recognize say FIFA official time. Inti now no ya ensan go back and go start game because sa 3 minutes na it does not go by no ono recognize sa 3 minutes no. This is what they are doing. And that is what Atachia is saying. He is going to court tomorrow, and that when he goes to court tomorrow, he's going to ask for 6 weeks. 6 weeks to do what? 6 weeks to write his submission. The question here is, your press conference will not change what happened on the pitch. Your press conference wasn't part of the rules. Your press conference, it is not what FIFA is looking at. FIFA is looking at what the referee basically at the end of the day saw as good or not. Into Atachia right now is saying, now, wabano, sa game in a course, we should go back for documents in Yinamado. We have 6 weeks. Now, let me show you something. Now, this was the ruling. I want all of us, and I've read this thing here about 3 times. Time Atachia, time Apia Kubi, Eko Kachire court to say, onye lawyer to Chema Wontumi Biemno. He went there. Thank you very much, team. I will add this to it. I think you did you add this? Did you send this before, or you just sent this now? Now, time appear could be muka say or court kakache a court to say on person be chema Wontumi lawyer bimno. The judge said something to Apia Kubi. And it is very important because and no I was a judge, she or he needs to stick to. Now, yanko time apia could be court ko ka judge and say or no apia could be no onye chairman Wontumi lawyer bi na mum attachia and ebe chairman Wontumi lawyer. Now, the judge said something that day during the ruling. Now, during the ruling of the judge, Mr. I have it. I'm trying to move it to the system. Thank you. During the ruling of the judge, Okabibi, and na me pese ochna, the judge must, with all due respect to the judge, with all due respect, I believe the judge should or must stick to those principles. Because I have seen, say, MPP for ne attach yamono, omo pese omu delay court no. They just want to delay the court. They just don't want the judgment to happen. And with all due respect to the judge, we want the judge to stick to principles because so far, judge na prove say or your honest judge and yet personal issues in the case in so. And yet obi no tano or percent obi that fair hearing. I believe say ochina before a judge no ebe tie attachia. Ghana for munim nyansa munim say asama yeken, we are basically speaking on the issues. The judge should first go back to his or her own hearing ruling. And no enebe chere say sebio asama attachia kind of court or chinano eto asuma na se ento asum. Because with respect to attachia asama or deba, it's all about written submission. And we know the honorable judge or the case we know, he or she, he has spoken or she has spoken on this witness written submission. Now, let's do this before we go back to her ruling because Enona, with all due respect, we are putting out that the judge should consider her own ruling. Because if we sit in Ghana and we are in a country where Obia to me criminal case. Now eka 2 weeks my judgment aba. Now obey use this same precedent as a defense to fire their lawyer to get a new lawyer there. Then no case will end in Ghana. Say and the court not allow this kind of abuse. Say court not allow it Chairman Wontumi lawyers to abuse the court in this way. The issue here is a day will come. Ni pebi edit bejina court. One, obe delay court na for 2 years. Now, it do 2 days. Now you be trying judgment. Obe catch Ghana for you we changing a lawyer. Okachen say we there. I didn't know I say also imbrebi, and with law it's all about precedents. Imbrebi Ghana law court ya. Nani pebi wo court. Na aka 1 month my the judgment aba. Oka say we changing the lawyer. Emma court jitu muma sebio yesa stati case libio. So this is a very dangerous the path we are taking. And we are not supposed to allow Atachia to hide behind something called a written statement or written addresses. Now, written addresses now Atachia ko jina ho court or channel. What does it mean? Before I read judge, the ruling when Apia Kubi ekoka chen se onye Chairman Wontumi lawyer biemu the judge na kasa faka ekafa written submission ho. The judge herself or himself on one case, what try a record him. Now, let me show you this. The main legal basis written submission come from. Now, written submission any day, in case we na judge a lawyer and can say, "Minam a lawyer to Kevin Taylor, make sure my opinion on the case." Any friend written submission. Now, a High Court of Civil Procedure Rules 2004 CI 47. This is what it says. In civil cases, the rules allow the court to direct parties to file written addresses submissions after evidence. It is therefore procedurally mandatory once the judge orders it. It is therefore, and this is in civil cases, the case we are faced with in court today, a criminal case. So in civil cases, any criminal cases, it is therefore procedurally mandatory once the judge orders for it. It is a civil case, say judge orders me per written submissions, that one you have to do it. And that only applies when it is civil cases. In civil cases, as I didn't see. Now, criminal procedure practices. So when it comes to civil cases, what happens is the court, the civil procedure rules, which is the 2004 CI 47. In civil cases, any criminal cases, no. Chairman Wontumi case were a criminal case. In civil cases, no, when the judge orders for written submission from the lawyers, it is an order and everybody has to put it in. Now we are looking at Chairman Wontumi's case, which is the criminal case. The distinction is very important. Criminal procedure practice. In criminal trials, there is no universal statutory requirement. In criminal trials, right now, attaching or lawyer to Chairman Wontumi, he's trying to make it mandatory. This is a criminal trial. Written submissions are not mandatory, and the judge's ruling, she said it or he said it. But the reason to attach court to say he is a lawyer to Chairman Wontumi who is facing a criminal case, right? Now, the law actually say in criminal trials there is no universal statutory requirement that written submission must always be filed. There is nowhere just a criminal case, what we call written addresses must be filed. There is nothing like it always has to be filed. You can decide not to file it. Nobody cares. Because at the end of the day, it does not affect the evidence before the judge. That evidence, the judge, I call it the judgment. This is a criminal case. Now, when you read further, that's what it says. However, courts increasingly use them as part of fair and efficient trial management, especially in the complex or document-heavy cases. So, optional. It does not say it's mandatory. It's saying, no universal statutory requirement. It is not a must. Atachia, when he goes to court tomorrow and say, Judge, mommy, 6 weeks, I need to write my written state addresses. It is not mandatory. And the court is not supposed to grant it. Because without it, the judgment can still be read. So what Atachia is going to do tomorrow, our court in front of the judge, the judge herself or himself about 2 weeks ago made it clear her point. And I don't think, with all due respect to the judge, with all due respect, I don't think that judge will eat her own words back. Now, when you do a little bit of reading on this same judicial discretion, now, judicial discretion, and this was still under this 2004 CI 47, it says judges in Ghana have wide discretion to, 1, order written submission. Judges in Ghana have wide discretion. And we say judicial discretion. Judge didn't so pay or in the decide. When you say discretion, send your wa opese we ye. Wan kasa nyoma opese ekoso. Enyamra and a show. So, your friend, judicial discretion. Judges in Ghana have wide discretion to order written submission. So, the judge could decide or can decide not to order for any written submission. 2, set timelines. The judge can decide not to set timelines and can decide to set timelines. 3, or proceed without them if unnecessary. The judge can go ahead and write their judgment without written submission, without the lawyer's opinion, without the lawyer's own understanding of the proceedings. The judge can still write their statement without even asking for any written submission. In fact, it is an option. It is not mandatory. What Atachia is trying to do, Atachia is trying to force the court to do something that is not mandatory. What is happening right now when it comes to written submission or addresses is optional. It is only in civil cases. And when a judge demands for it, it's that even that one, the judge has to demand. In a civil matter, it is the judge who has to demand. But in criminal cases, no, it is optional. Now, let's go back to this same judge. When Apia Kubi echoed the Nimko and say, I don't want to be Chairman Wontumi lawyer again. And that Chairman Wontumi has a new lawyer. And that stop your judgment because Chairman Wontumi has appointed a new lawyer. What did the judge say? And let's be fair here. This is a judge for a very long time. Wa accommodate the Chairman Wontumi. Wa accommodate all the things Apia Kubi here. Now, it looks like Atachia wants to take over from Apia Kubi in this kind of cunning delayance when it comes to this criminal case. Now, let's go back quickly. I had now say pay all the attention. And it's about Judge Nankasa or no time appear could be Jina in Nimka say, me yet lawyer match my own to be beam. They say attach neighbor into delay with judgment. And then a judge we Ankasa Kaya. This is the same judge with respectfully. Ochina attaching echo Jina in him say, or not attaching a demanding. Because at this point, attaching is demanding. Attaching is telling the court that the court needs to do that. But in law, in Ghana's legal law, the issue is it is not mandatory in a criminal case for written submissions to be demanded. And I say, without written submissions, a judge cannot go ahead and pronounce judgment. No. Now, so we judge Nankasa, ne Seville the ruling when it comes to day now appear could be echoed in him now. In fact, let's read this one. Debia me read this document where me read and FR then a judge in the kind of timer appear could be called in him say onye dein onye chairman Wontumi lawyer bim a then a judge in the kind. This is the ruling from the judge. This is a few weeks ago. Into moment a judge in the position on a written submission. And sana ochina attaching a court. Ako catch a judge and say because of written submission, judge into judgment and shada. Let's see a year the judge in case when she was or he was ruling on that appear could be issue. What did she say? What was her opinion, legal opinion on written addresses? Now, I'll say, consequently, since filing of closing addresses is optional, time na appear could be catch a judge and says, see, I mean, my Wontumi lawyer beam, attach an obano, says, no, or then a eba betro written addresses into a journey case, no judgment, to another date, send a judge the catch or see. Consequently, since filing of closing addresses is optional and not a function of the rules, that is to say, there is no provision under the rules compelling the lawyer for an accused or prosecution to file an address. According to say, addresses are optional statements made by lawyers. Listen, written addresses are optional statements made by lawyers to articulate on the merit or demerit on a case one way or the other. Or say, what we call written statements are optional. In fact, those written statements, they are done by lawyers to what? Tell people their opinion, to articulate their opinion about the whole game. It is like a press conference. Technically, written submission or addresses which lawyers write after cases are heard, evidence are provided. In criminal cases, they are optional. It is basically the opinion of the accused's lawyer or the defendant or the prosecution. At the end of the day, it's just an opinion they are expressing. This is like post-match interview, post-election interview. Written addresses are just court interview. It is the same as somebody going to court today. Appear could be court in the new appear but not journalist able to question. It is basically daily written submission or addresses. Appear could be every day he walks out of court. He meets the press. That is the post court proceedings or press, his views, how he articulates, how he sees it. The merits and demerits. Oh, and the court, na be fine. And the moment the judge, I say one thing. That is his opinion, and that is the same thing here. It does not affect what actually transpired in court. The evidence that was put before the judge, the evidence that was put before the judge by the accused or the prosecution. No, it is just his opinion. That is why during this judge's ruling 2 or 3 weeks ago, he or she was clear that written addresses are post-court addresses. They don't affect what actually happened in court. They don't affect the evidence in court. It is the opinion of the lawyer. So the question here is, if it is just an option, it is the opinion of the lawyer, how can it affect the evidence put before the court? Because post-court reaction is done daily. Now, it is all the post-court reactions that you have seen From day one, appear could be record, opie, or chena general, and no, optionally, he can decide to put all together in one big document and say, this has been my opinion from day one. Every single day, I share my opinion, but today, I am going to put everything together. I'm going to summarize, compress it for people to know my opinion on the whole proceedings. So, submissions or addresses by lawyers do not or cannot have an effect on judgments. Now, already judge in the last statement, or say the court would by this extend the time of filing written addresses from 17th of June to 24th of June 2026. For the avoidance of doubt, this matter is adjourned to 9 a.m. on the 3rd of July 2026 for the court to deliver judgment in this matter. Meaning, the judge herself or himself made it clear, I don't care about written addresses. I don't care about post-court addresses. What I care about is that I've given a date, and that date, the judgment will be read. And see, what I'm trying to say is, I'm just asking the judge, is she or is he going to eat their own word or his own words or her own words? Because we didn't know this until the judge sitting on that case told us that when a lawyer, after every single court case, walks out of court to share their opinion, is basically a written or oral witness address. Now, the judge made it clear that those things are optional, not a function of the rule. When they say not a function of the rules, it means court. So without written submission or addresses, a judge cannot go ahead and pronounce judgment. No, that is the statement. That is the meaning. The question here is, Ochina, Atachia Echo Court to say, Yanko extended time, Mano, all because of an optional written submission. At the end of the day, why should the court, with all due respect to the judge, at the end of the day, why should the court even hear Atachia out? Because, so we read the judgment now, she even gave Atachia enough time to also write their submission. Now, when you read the last part of a judge ruling now, or say, the court will by this extend the time of filing written addresses from the 17th to the 24th, meaning the judge, nobody was compelling the judge to even extend the time of written submission. It's an option. If you want to write it, then I'm giving you time to write it. If you don't want to write it, I don't give a fuck about it. But a judge in her own wisdom, wanting people to say, at least I'm being transparent. I don't want people to say, oh, I did not even allow it because I'm not supposed to demand for written submission. It is not part of my judgment. The law does not compel the judge to say without written submissions from the lawyers, she cannot or he cannot bring out his judgment. So the question is, why did the judge even give him more? The judge was being more lenient from day one. Much now how they have abused the court. The court was being lenient to Chairman Wontumi and his lawyers. For the judge to even say, I've moved it from 17 to 24th, the judge was even being lenient. The judge knows it is not important. But if it's for the optics, fine, I'll give you 24, write it and go and show it out. So from the 17th to 24th, Atachia could not contact Apia Kubi. Atachia wants to tell me when Apia Kubi was handing over Chairman Wontumi's case to him, Apia Kubi didn't give him the proceedings of the court. Is that what Atachia wants to tell the judge tomorrow? When Atachia was given in room from 17 to 24th, Atachia came back to tell us that the registry did not give him the documentation. So you could see clearly that a plan, the same 442 formation, he wants to continue. It is the abuse of the court. So with me, or when you ask us, Loud Silence Media, my editorial team, we believe that the court should not even listen to Atachia. Because you see, let's be realistic, let's be real here with this matter. Say me a criminal case that me if I'm being accused, we are talking about Gift Owari is being accused of criminal things in Ghana. Obi to say a SkyTrain, a criminal case. We are talking about a buffer stock, a criminal case. There are so many criminal cases at Ekoso Court. The lawyers are watching. And with all due respect, I am talking to the judge. You yourself said that there are no rules binding you at the end of the day that without written submission, you cannot come out to your pronouncement, which is fine. We understand, we respect that. Now, imagine all these smart lawyers are lawyers to these accused criminals, trial, and then what they are going to do is, if tomorrow, Sir Judge Way, knowing that written submissions are optional and not mandatory, and no law in Ghana in the legal framework is mandate any judge to say without written submissions, I cannot come out with my judgment. If tomorrow, Sir Judge Way, 6 weeks, go and write her, what is going to happen is all the criminal cases we are seeing in court, and we are working with precedents here. This is legal field. We are talking about precedents. Edubuahen money ade. Lawyers in there. Edubuahen lawyer she. Skytrain lawyer she. Give to a warrior lawyer she. Buffer stock lawyer she. All the criminal cases in court today are oral. Lawyers she. Remember, Sir Judge Way, with all due respect to the judge, Ochina decided to be granted attachment 6 weeks. So uncle now Abra Odim say any mandatory from her own ruling. No, what is going to happen? And say, some cases when they will drag it. Now lawyers of these respective cases will drag the case. Eka 1 month. Not judge, adding the judgment about. They will come and tell you, the accused will tell the court to say, you know what, I don't want like my lawyer again, and that I am bringing you a new lawyer. And what that lawyer is going to say is that I am basing my application on that application that was granted when Atachia took over from Apiakubi as a new lawyer who was given 6 weeks. So me too, right now, the accused has changed his lawyer. I am the new lawyer. I am also telling you, and court is all about basing on your statement on facts and evidence. All the lawyers are going to wait. So Ochina, if this judge respectfully, this honorable judge says, oh, Atachia 6 weeks, all the criminal cases, we will never finish the cases. I'm telling you. All those cases, none of them will be concluded in Ghana. Because all that you need to do is that, as an accused person, get 4 lawyers on standby. Every time your case echo close, no new lawyer, not another one about, you know what, I need to go back and look at the whole case again. So, with all due respect, my lord, give me 6 months. I need to go back because this case has been in court for 3 years. I have to go back from day one and analyze. Or now also 2 days my judgment about, or say I don't want to work with this client again. Now another lawyer. Can you stop them? No, because the precedents have been set. Because you, the judge, with all due respect, you created that room. You have created that hole, and all of them are going to use it. Let me tell you, when it comes to cases in court, you know the Gamanches case in court. When my case was in court, the smart lawyers of the Gamanche basically, some of their argument in court was based on my case in the Supreme Court. Yeah, go and read. Because no case is stupid case. So all these criminals, they are lawyers. They are sitting and they are waiting. They want this judge to open that window tomorrow, and you will see what will happen in Ghana. No criminal case will end in Ghana. Because if they are precedents, you cannot tell me you won't give me that. Why did you... the court, and at that point they are not looking at you, the judge, they are looking at the court as a body. Until when you refuse to give them, they will go to Supreme Court, they will go to appeals court, because why did you give Kevin Taylor, you don't want to give me? And this is law. You cannot say that, oh, the last time the judge gave, I cannot give. No, the lawyers will say, me too, I am changing, I have been changed. You need to give the new judge, the new lawyer, that 6 months, 6 weeks, and it's going to be part of our legal framework. It is dangerous. The moment Atachia is granted this tomorrow, our legal system will break down. No criminal will enter jail. No criminal can be prosecuted. No judgment can be read in Ghana, because now all that you do is you wait. Judgment bar. Eka 3 days, no change new lawyer. Who change new lawyer and new one bar? Or say, please, let's start from beginning. Okay, so on TSS, no, let's go back. The president, it happened in 2026. Atachia took over from Apiakubi, and he was given 6 weeks. The same court. Why are you choosing today? Now I'm going to go to appeals court. I'm going to appeal that 6 months. So we need to be careful. And I believe that Ochinano, this judge, I don't know this judge, but I believe say or a one smart judge or wabutra or a very transparent. And the lawyer for Chairman Wontumi onim dia oye. Let's not create any room for these people to destroy our judiciary. Because Ochina, Your boy whom is a mistake. Na yaka say, oh, Apia Kubi, and a dema attaching, go 2 weeks. Even 2 weeks is dangerous. 1 day is dangerous. I am telling you. Because all these criminal lawyers, all these lawyers defending these criminals in Ghana, they are waiting. Obuoha, or you said the next 6 months, the case, no judgment beba or train. Obuoha in the next 1 year, or you said the case, no judgment beba. Obuoha, you said in the next few weeks, judgment beba. They are waiting. Tomorrow, if this judge grant Atachia this, no case will end in Ghana. I'm telling you. And you see why the MPP is doing this? They know that the MPP, they have an election. And NPP to conduct national executive elections between September 18th and 20th. Now, on the Atachia so 6 weeks. 6 weeks, no, it will enter into August. Now, you can even say, oh, now said this one, August, this September, this is what they are trying to do. So we ways to free war. What is happening? And they say, the judiciary in Ghana, the Ghana judiciary's major annual break, the long vacation is about to happen. Officially takes place from August 1st through September 30th. Now, Atachia was 6 weeks. It will enter August, August 1st. Meaning, technically, there will be legal vacation. The legal vacation takes about September, about 3 months. ODIN is a limited 2 months. Meaning, for the next 2 to 3 months, there will not be court. What is going to happen is, it means during this period, superior courts are generally on break, but selected courts, typically within the law court complex in Accra, are designated to sit on rotation to handle urgent and pending cases. When they say selected court, it could be that where Chairman Wontumi's case is not part of the selected court, meaning Chairman Wontumi's case will never end. There are two things now attaching pushing this case to MPP primaries. Now Mutumbe Chairman Wontumi, then the conversation would turn around. Kofi Bentil then Nkwasi Afomabet now. Oh, you see, the national chairman of the MPP, Chairman Wontumi, is being persecuted. They want to print that message out. They want to create that impression that the NDC government, when they came into power, a criminal who was involved in illegal mining, where he was put before court with all evidence showing, hey, that guy is the national chairman of the MPP. So to them, it is not about the law being applied. To them, it's about using the law against us to protect their criminals. And the judge, given 3rd of July, the judge should not, even holiday crow also set it, not already judgment in the Ghana for. Because you mistake. Now allow this judge, with all due respect to the judge, you mistake, now judge now allow this to happen. Atachia is not here. Atachia does not have any evidence to protect Chairman Wontumi. Atachia onim law papebia. Atachia is somebody coming in to delay the court, to disrespect the court, to frustrate the system. So what they want to do is, they want to go for their conference or whatever quickly. In Tomukope, fast. Na yanyi Chairman Wontumi, because Chairman Wontumi, the guy says he can or the share Baumia campaign. We all know Chairman Wontumi works for Baumia. And Baumia is the one manipulating the party now. Onona Osheche so omunya pam kere de Japan, because onene yire no on the party come charge for. Now what Baumia is doing now and say Monya nentam mama Atachia ko delay Chairman Wontumi case no court. Send be to my prime minister no na delegate na be Chairman Wontumi. Send be Chairman Wontumi ruling ne bana e bia etiana na aka che wiase nyina say the national chairman of the NPP is being persecuted. But we all know Chairman Wontumi, what he has done, the reason why he's in court. Mamu Maya allowed the MPP to destroy everything. And I'll plead with the judge, with all due respect, Mr. Judge or Madam Judge, with all due respect, this is a very important case. Memenko Law School, so many people watching us, we have not been to law school. So far from the day this case started here, everybody has seen the transparency, the honesty of the case way. My interest is not to see Chairman Wontumi in jail. My interest is to make sure the right thing is done. Evidence, you write a judgment that nobody can contest. So I'm not here forcing anybody to jail Chairman Wontumi or let Chairman Wontumi go. My job here is to explain the process. If we are building, if we want to protect this nation, we need to do it right. Let's not allow some people, because of their political greediness, destroy the last pillar. Because the judiciary, basically, is the only thing that, at this point, some politicians are scared of. If we go tomorrow, we listen to Atachia, and we force Atachia, forces himself on us, lie to the court, and we basically swallow our own ruling and what the court is against. That is why I've read your own ruling to Ghanaians. And I know a judge like you with all the experience, maintain say for once, and a nipa could be able to accuse you of anything. You have shown professionalism. Please, let's show this professionalism. Let your word be your word. Let your word be your word. And your word is that written submissions are optional. Written statements from lawyers does not affect judgment. In civil matters, a judge can mandate for that. In criminal matters, you said it clearly, nowhere in this world. And a written submission, a mandatory. So at this point, you have made us understand it is binding. Written submissions are not mandatory. You can go ahead and pronounce your judgment without even listening to Atachia. Atachia's post-court analysis, it's to his own benefit. It's his own opinion, and he can exercise it whether today or tomorrow. He has the right to do that. But the law, the court, only recognizes the evidence before you and the date you have put out. We will meet tomorrow. We will discuss Ghana. We will make it clear. Ochina, a year Attorney General will be in court. Ochina, a year we will all monitor. And remember, you know one interesting thing? Atachia we are, he's trying to lie again in court. You know? He's the lawyer for Edubuahin. So, Madam Judge, Mr. Judge, you see what they are trying to do. If you listen to Atachia tomorrow, and you grant Atachia 6 weeks, 2 weeks, even 2 days, the same Atachia will go to court and cite this same ruling by you tomorrow, if that is where we are going to go. Because Atachia is a lawyer for Edubuahin. Edubuahin's case is close. They are about to end the case. If you give Atachia this, which you know, and you have said to us that it is not mandatory, so because Atachia enco 6 weeks, enco written submission to judgment in Ma. Remember, Atachia is the lawyer for Edubuahin. And if you give Atachia this, when Edubuahin case ebedu and the judgment is about to be read, Atachia will step away, bring in Apia Kubi, and Apia Kubi will tell you that, do you remember this court? Because we are dealing with the court, not individuals. They will go to court and say, does the court remember that during Chairman Wontumi, Samra Boy criminal case, Atachia, who is now not Edubuahin's lawyer, contested that written submissions were important and that judgment was supposed to postpone. Do you understand? They will cite that. It will be the precedents they will be using. Atachia is setting 2 goalposts for himself. He wants to shoot without any goalkeeper in them. And that is what he will start from tomorrow. Let's not give them that. Especially when you, Mr. Judge, Madam Judge, you have made it clear that written submissions does not affect judgment of a case. Meaning, there is no case here for Atachia to make tomorrow. Meaning, Ochina, there is no case here. This guy is the same lawyer for Edubuahin. He will basically take Edubuahin to the final day and say, I'm no more his lawyer. Let Apia Kubi come take over, and Apia Kubi will cite Atachia's decision you are going to make tomorrow. So the best for us all as a nation, now that the law says it clearly, that written submissions in criminal cases are not mandatory, not important. Madam Judge, Mr. Judge, with all due respect, tomorrow, just quash this nonsense and then come out with a judgment on the 3rd of July. This issue is got to do with Chairman Wontumi. Last week, what actually came up? Wontumi Samra Boy trial. Wontumi's lawyer, Samuel Atachia, has urged the High Court to defer judgment beyond 3rd July 2026. Now, citing the registry's failure to furnish him with the record of proceedings needed to file his written submission by the court ordered deadline of 23rd of June. Now, last week, Atachia said, they say, the new lawyer, Emma Chairman Wontumi. Now, Sisiano, or no, I catch record to say, even though court, I catch and say, Onko na onko jinkrata na proceeding documents no na on study. In fact, nanka was a court no on the 17th of this month no. Na adwene say nka onji written submission bia emfree day. the defense counsel. But because Chairman Wontumi ebeka kire court to say, ono eye Chairman Wontumi no, oni appear could be any maybe because appear could be Jimmy no. The court actually said to say, even though any mrem say or say appear could be back court, ebeka kire to say oni Chairman Wontumi nyejuma because on the rented Chairman Wontumi and also or high or decides or render the services ama Chairman Wontumi. Inti see and on the Chairman Wontumi nyejuma bi ma. The court has nothing to do with it. But the court, out of respect for Apia Kubi, and also not to look like they are preventing Apia Kubi from explaining himself why he's not a counsel for Chairman Wontumi, no, the learned judge actually listened to Apia Kubi's vague statement in court. Oh, we are not the answer to us. Okay, so Chairman Wontumi akofa a lawyer for attaching. What she said, I want to rule him say. A year from the 17th, we move the 23rd. Now, a year attaching or the new lawyer for Chairman Wontumi, no, on to making sure send a written statement, no, or the aba. Now, remember, judge in that day, no, or a ruling be. Now, ruling here very important. The reason why the ruling is very important to Ochina Court or Moko and the Chairman Wontumi judgment, and then say, judge the ruling, no, she was specific on some things. She was basically emphasizing on Nyomebia and to me affected the 3rd of July, a year next month, a year ruling. No, into those are not that ruling here very important. I will say, Yejina Adjune Ekosi. Obeka Saturday and Sunday, Kevin Ekas has because Ochina something might happen in court. And when I say something might happen in court, and I say meaning BBC, but I'm trying to let you understand what Chairman Wontumi and then the lawyers so they are trying to do. I want you to understand what they are doing and why court is supposed to be very careful dealing with Chairman Wontumi and the lawyers, because the abuse of the court by Chairman Wontumi and then the lawyers from day one, it has been there. But the court, for some reason, ama Chairman Wontumi and then the lawyers too much room. And my fear is that at a point, abuse Chairman Wontumi and then the legal team abuse the court, it will set a bad precedent. Some lawyers in the future might capitalize on the court's generosity. You see, the court, Samrabo case, criminal case, I believe the court has been very generous. And when I say very generous, there are so many things that the court, in Isanka or more penny money secret during the trial. But for some reason, the judge on the case decided to give the accused all the opportunities to exhaust every opportunity. Send a Obinko Jina Bebinka say, Nambe call court, and I Chairman Wontumi lawyers because say, your call court, there were some things that were not in our favor, and a court, I believe we say the court has been very generous, but the generosity in a court, show Chairman Wontumi lawyers, they are abusing it. Now, Apia Kubi the status are abusing, they have abused the court for a long time. Now, there's one thing, say, court, they decided, say, because they want to give Chairman Wontumi the opportunity to, at the end of the day, defend himself. Now, court, and she say abusing the area too much. There are other legal brains. There are other people in court. There are other people who are also facing the criminal trials. They are taking note of the court's generosity. When it comes to legal matters, there's nothing like generosity. What the law is the law. Basically, that's what I'm trying to tell you. The law is the law. That's why when people go to court, when lawyers go to court, they use acts. They basically base every statement they make on a precedent, on facts, because court is not a place to speculate. Now, the moment you give people the room to abuse the court, even you being generous, you are creating another avenue or window for somebody to also abuse the court. And sometimes in court, because judge way on judge, because the reason is that the moment you try to be generous, not biased or trying to allow somebody to walk free, the moment you try to let people feel like they also have the right to express themselves, defend themselves, the more you become generous, the more you do what? The more you create room for the court to be abused in the future. And that is what I have seen over in fact, since Chairman Wontumi case in start here, the counsel and our lawyers of Chairman Wontumi from Apia Kubi, ABC Atachi, they have seen abusing the court, because the court allowed them to do that, Apia Kubi cry free hono, Chairman Wontumi Ekofa Atachi, and he also wants to do that. And that is dangerous for Ghana's court. It's dangerous for the judiciary. It is dangerous because other people are watching, other lawyers are watching. Now, there are two things you need to look out here. Or see a judge no ruling. before Atachia was brought in as the lawyer, and secondly, how Chairman Wontumi, your starting case with criminal case with na Apia could be a lawyer, no, how they have abused the court to this point. Now, my main show idea. Recently, Ohona Atachia ever grantee interview. Right now, Atachia is the lawyer, Emma Chairman Wontumi. Team, stay with me. Sorry. Atachia ever grantee interview, no. Atachia said, Samra Boy case, 6 weeks will be enough for me to prepare my written statement. As we sit here, Atachia is going to go to court tomorrow and ask for 6 weeks. Almost 2 months. That is 6 weeks. 1 month, 2 weeks. Ninyana say, or see obeko court or chira no ako plead with the judge and say, man is 6 weeks. Now on fan study case from day 1. Court day 1, day 2, day 3. All the documents that were shared in court, case management period, a year witnesses statement, or say, judge na a man is 6 weeks now on to me fan studying in reading in. But remember, say a man is 6 weeks not already sign your way in no EBBA. Written submission. After that, obey read actually, does it really matter here? Is it very important? Does it have any effect on the judgment? That is the question we need to ask. Say, am I attaching 6 weeks? The question is, 6 weeks there, the man no. Oh yeah, what is the end game? The end game is obey written statement or written submission or written address, whatever. And that is his opinion. Now, at this point, does it really matter to the judgment? Does it really matter? Will it change anything? What did the judge now or case now about written addresses or submissions? Written addresses or submissions, does it really matter at this point? Now, before we continue with this 6 weeks, Chairman Wontumi lawyer Atachia, the strategy they are playing to delay the case, not for the case to even be judged this year, let's step back a little bit. Now, Mukai say case in the question BBC, and these are some of the abuses I'm about to show you. Make sure case in the question, senior Chairman Wontumi appear could be abusing court, for some reason, the court actually did what? The court allowed it to go on. And I'm not saying the court allowed it to go on in a bad way. The court basically felt Chairman Wontumi needed all the time to make his case. But court now allowed that, What Chairman Wontumi lawyer Apia Kubi ABC Atachia did, and they said they abused it. Making sure say, chance na court dia mom no, be say no, de be good court no hu fi, de be chere say court no mumbu no. Now let's step back a little bit. This is a court proceedings. Nya opportunity me. Now proceedings we know, and this is what happened in court. It happened around the 3rd of June, all the way 3rd June. Satana case no koso. Now, you see this document, it's public document, and media a court. You can go to court tomorrow, they'll give you all the documents. We can also publish this tomorrow. This is not Kevin Taylor's document, and this is a document anybody can have access to, a court document. Now, on the 3rd of June, I sent me to your court. That is how Chairman Wontumi and then the lawyer Apia could be abuse the court, and so the Atachia wants to do that from tomorrow. Now, that's 2 p.m. Date the 3rd of June, and so accused persons A1 presents and present A3. Sorry, presents and represent A3. Now, the counsel, Dr. Justice Srimsai, or the Deputy Attorney General. Basically, he was also the lawyer for Ghana. Let's make it simple. Now, Saul Stadia should you see a timer na case in the coso and see how Apia could be what he did in court. Any judge be only abutre, any court be they don't want to even listen to Chairman Wontumi and Apia could be that time ni no and ka ushebu pa na this case do this point. But all these things, Chairman Wontumi and the lawyers, they never spoke about it. All the things they did against the court, all the deliberate action they took, no one say it was going to delay the case. The judge still had that had to accommodate Omo ye nyoma kodru point bi a judge bia se bi on person betie chairman Wontumi ade timu odin a opese oye quick no o judge asam no anka se bi obegina sa adwoma ne su nyina ajudge asam no but judge ni nya abotre o wiase nyina ama chairman Wontumi Emma eye apia kubi ene chairman Wontumi mo e disrespected court no on several occasions but the judge still believes say it was a chairman Wontumi enya fair hearing. Fair trial is very important because he is just an accused or yet somebody who has done it so far as we speak. But so when you now come back into court proceedings, now share idea appear could be deliberately on year or court. Na judge na cause the bufu. Now I say no. This is too much disrespect. Eye de nimtiano doso. Just say we are lawyer paying awudi chairman Wontumi enim but dia wo ye no I say we need the ho na opese ubu court nimtia enimtia na udi di Ghana for the atem. But what happened was that judge, did not do anything. And when I said did not do anything, the judge could have stopped the case there and said, hey, Muni Bibia, the way you are disrespecting the court, and I want to go ahead and write my judgment. But the court accommodated them. The judge sat and did not even react until at a point, Judge Rika said, no. The abuse is too much. You see, to the point, after Judge Rika said, this is becoming like a strategy of Apia Kubiniche Wontumi. And to the judge at a point in court, the judge made it clear to them, said, no, the disrespect to the court, the disrespect to me, the disrespect to Obiano, deliberately a counsel and as a lawyer, deliberately changing things even in court. Case management or to be back court, all of these things, judge can say, what Shah would say, appear kubino or a lawyer be I just say on canocre, I just say oh delay case, because the technical judge will be a bias. Na actually here the cell person jelly chairman Wontumi and case in Kendruha. But this judge feels to say chairman Wontumi needs to be heard. Chairman Wontumi the witnesses are supposed to come. Chairman Wontumi whatever is provided we need to. But it got to a point you could see say chairman Wontumi and Pia Kubi they were deliberate in their actions. They wanted to abuse the court. Per se almost say case and I could and I'm doing this and I say. That is the same 442 formation and at the end, attaching a picky free. They just want to delay the court. They don't want the judgment to happen. It was attaching us also called court or compare 6 weeks. On family study documents. Abra case near KWA. Now, my mention you see what court and why attaching to me respectfully to the court without the respect to the judge. I believe attaching is not even supposed to be heard tomorrow. That is what I believe, myself and my team. I believe, say, the disrespect from Chairman Wontumi Council 1, Council 2, it is too much. And the same strategy, the same thing I did attach and I believe, say, the court is not supposed to tolerate this. Now, you see, when you read on the 3rd June proceedings, you ask yourself, say, but why was the court allowing this? Now, Mami Ridi Adewenshaw, this is what happened in court on the 3rd of June. Oh, sorry. On the 5th, right? Yeah. So, on the 3rd of June, I'm call court I didn't see any. So, on the 3rd, almost on the 5th. But the judge had to address Adibia, Apia Kubini Chairman Wontumi, Ababe P attaching is doing same. And that is the most dangerous part in this case. Now, Hadia, let's take our time and go through what actually happened in court. And these are some of the things that attaching is asking for. And these are things that are documents that he can even go to Apia Kubi and demand. But because he wants to delay the court, he wants to abuse the court, that's why they are doing this. But sure, before Ochina Omako Court. Now, on the 5th of May, 2026, this is 5th May, near June crowd. Now, they see a court. The accused person filed 2 witness statements out of the 5 witnesses they listed. Now, on the 6th May 2026, the accused person filed another witness statement, making 3 in number. They, however, informed the court of their intentions of filing 2 witness statements in addition. The court conducted CMC on the 3 witness statements and proceeded with the trial with the anticipation that the 2 witnesses, the other 2 witness statements will be filed by the accused person before the end of cross-examination of the other 3 witnesses. So, I'm file witnesses say sa nipa we na your call case management your person omoba. So on the 6th, the accused person filed another witness statement. Remember, on the 5th, the accused person filed 2 witness statements. Now, out of the 5 witnesses they listed, inti na or say or nipa or witness statement 5 Sibiu wa filing. Now, what happened is on the 6th, even though on the 5th, okay, say 5, on the 6th, a buy afi or say they can only file only 2. But during the CMC, that's the case management, they said they were going to file 5. Omobedu court on the 6th, almost they are going to use only 2. Now means 3 now also file famba. That's fine. The court allowed them, and then you can see it was a deliberate thing they were doing. Oh, yeah, the nipa 5 remember. Omuni ebe from our bad kim abeka omano asem ne atoto omano no maboa me with a chema Wontumi. Afiom could court pena dani. Oh, yeah, the new pen ebe bande. Abra bodin kan aye case management judge atia say oh nipa num na bia and ombeba nipa num na ya file ya be free we and the ochane afree we no what they do they say omokoye sa meeting wie no mudru court pe na apia kubi we change bibia instead of 5 statements both are adani 2 and adani 3, and this is what transpired on the 5th on the 6th of May. Now don't worry, yanko nam chwade. However, at the end of the cross-examination of the 3 witnesses, the accused person had not filed any additional witness statement. Inti, go ahead still. And then they did what? They cross-examined the 3 witnesses from Chairman Wontumi. Now, the funny thing is, time cross-examining of the 3 witnesses, the accused, Apia Kubi, they had still not filed witness statements of the other witnesses. Now, the court cautioned the accused persons and gave them 7 days to file additional witness statements if they are so minded. Inti ema court bufuye, judge ni bufuye. Eno ka say Apia Kubi. Sa ankofo ya wo se omo ba be witnesses amache ma Wontumi. Me ame ba be won yomo. Say omo empe omo ho asem a omo mbra no be file omo statement because on paper the CMC case management actually say also be file na yetumi ko enimo case no. Inti ema judge bufuye o court. Eno ka say de mo ye no nyanse bi enim yekọ case ni nyina ho adwuma behind the scenes say nipa dodo say na ebe kasa we na beto yebeduru pe na wo Apia Kubi ne Chairman Wontumi enkofo wo so mbe kasa no na sebio yehu bebi omonam omo statement so omo famba. How are we moving forward? And all this the judge had the patience to listen. So at the point the judge said no, I need to send a caution to omo jatum so mba witnesses for Chairman Wontumi. Now, this is what happened on the 25th of May. So from the 6th, the 25th of May, something happened. On the 25th of May, 2026, the accused persons filed a 4th witness statement in the name of Honorable Kobna Ochredaku Mensah. The court conducted CMC on this witness statement and proceeded and adopted the evidence in chief of the witness. Cross-examination commenced. The mouth of the witness was sealed and matter adjourned for continuation of cross-examination. Right now, naka witnesses mienu Chairman Wontumi Apia Kubi be file. So judge ni ma sa caution no. A mu say judge ni bu fuba no. E no ba omde ba ko ba so ye de ba ko aba. Na ba ko na Kobi Ochredako, the former Western Regional minister. Akwana de nise petuo no. Gibi no numi no. So when the guy came to court, they see and they say, Apia Kubi mo making sure say won kasa. Cross-examination you better to a witness no. Apia Kubi any Chairman Wontumi ba no. Almost so effort strategy be say witness no. And he say obi na no kasa. Almost selina no. Almost person obe answer to anything. And that day no. Yentumi ndi jumebia or court. And a court case, you know something. Let's adjourn. Yentu case ni sheda. They use another technicality to prevent the witness from speaking. When they were in court that day, Saturday ni so no, awosanka Kobi Ochredako Attorney General in Samano no, ono so to obudi yebusana, ono so person bekasa. Emma waste time Emma Apia Kubi use delay tactics for court. Eka say because of something, me client into me kasa because of Emma Akwano sorry Kofima yentumi antena case ni so. Emma judge ni sa to case ni sheda because the time not time na court. And remember, from the 5th of May, judge need to make nyadian abutre for all these things. from the 5th of May to the 25th of May, no, anka witnesses ni nyina anka cross-examine, but appear could be deliberately or making sure say a court no schedule no or best schedule no because he wanted to delay the case. He never wanted the case to end. And these are some of the things they did in court. And the ABPH, a year attaching so picky from here. So I had to say a baton. We echo kakra no da come away. Now we have a delay. So it's a delay strategy. Now, the same court, I'm sure the court is here. They see any before continuation of cross-examination, counsel for the accused, that is Apia Kubi, person informed the court that. Let me take this. Before continuation of cross-examination, counsel for the accused person informed the court they had filed a supplementary witness statement in respect of the same witness. In terms of court to be able, I feel that appear could be catching the court to say a year could be or the statement I had yet to my yebusa and no asem appear could be say was I filing another statement, a casa statement no home. Until say a better statement na tumuno, sa a year could be to mean casa. But remember, answer na witness babet na dakem ne abusabusa na no nsem no ye frɛ BCMC judge no on it 2 lawyers no ehia behind the scenes no mo nyina age eye questions ebe busa nipa no atum ye wi a na ye de ama eye court no eno na ye dru court e bedi hu nkomo. Now what appear could be did and say statement na eye Kobi Ochidako edin kan attended in say eno na eye ne witness statement attorney general ebe hwe so adoto na no ade achi bi no betena court a appear could be catch the court say ne witness no esa another statement bi or person de saka the statement no meaning sa first statement na da ho no yentumi ndi ho adwuma yensan kɔ biem ne yenkoya another CMC case management behind the scenes na yen first supplementary statement ne san kan ne witness statement no meaning it's a clear strategy to delay the court. And all this while na judge no won't show any anger. The judge was still accommodating Apia Kubi. Kobi Ochirakuba first time, almost Selina no manankasa Apia Kubi making excuses. Ade chibio matnasia Apia Kubi catch record say, oh, me witness no one send me can you run po finti aside be ka ho. Na eno no because court engine to munti, they are not going to allow a cross examination. Omo pese court engine supplementary edien. Na asam ne saka ho ansa na yatoa so. Meaning the delay tactics is in force. They just don't want the case to move forward. Make sure the delay on my bedroom na on my abuse court na and the court should not allow Atachia to even make a statement in court. The judge or the court should not even entertain Atachia because Adia Apia could be a year from day one basin. That is what Atachia is continuing, and it's also up 6 weeks, and when you give him 6 weeks, you ask for another 10 weeks. Now, Mamechiro abuses Nibi. Now, so when this happened, now the judge started getting frustrated. The judge started getting angry because it looks like say the taxpayers' money every single minute we are judge we are basically paying the judge. Every minute we are general court, we are basically paying them. So the judge is like, you know what, the taxpayer, we cannot waste their money like that. We need to basically move on, do the thing. I said the piano, I appear to be chairman want to be bar. Witness cra witness about na document ya printed document obianu se we dey be some question or say witness so akai bibi inti no yen to be nkasande yen fa nko kan ansa na witness na kasa. Now the judge when something happened. Now, notwithstanding his so this is what happened. Notwithstanding this irregularity, the courts obliged and conducted CMC on the supplementary witness statement and proceeded with the trial. Inti appear could be by and so yes, I was statement be a Kobi Ochidako asa account and agree into a the account and I consider no problem. Say mo per se supplementary e no de kan ho a court tina court omo gitu no so mo san fan ka ho. Because we cannot make this thing delay the case. Yen to me must have supplementary statement we end delay case. Until the judge was patient and the judge said, you know what, we whatever you want to do, we will accommodate you. So the judge accommodated the Apia Kubi guy again. And also, and the judge allowed that to happen. 3 times, these people have abused the court. The judge did not say anything. The judge wanted the case to flow. The judge did not want to be seen as biased. Judge Bia said, he or she would not even entertain this nonsense. He would just move or she would just move. But this judge took her time or his time to be taking all this nonsense from Apia Kubi. Wontumi. Now, make sure they see it. Now, the judge decided to speak after all these things. Now the judge decided to speak because now I feel it too much. Oh, when at some to me 1 week I cannot. Now we are spending 3 weeks or a month on it. Witness a bit to me across examining in a day. No, we are spending 2 weeks on one witness. So the judge started getting frustrated. Said no, I didn't know. And I said more abuse court. And I say, Mashallah, and person will say, delay Ghana. So the judge says something. I say, I have painstakingly gone through the trajectory and conduct of case management conference in this trial, mainly because my attention has been drawn to a witness statement filed on the 28th of May 2026 in the name of Honorable Evans Adai, who intends to give evidence for and on behalf of A1 and A3. Also, when you would say at Nasi, Akinkan Case Management Conference, that is CMC, meeting on behind the scenes and Sani Abakota Bekasano, I will be adding document bachelor judge. So when you be someone no. Also, when you would say I study ako back ako check a case management conference or no accused any the prosecution or not say and when we say one witness a friend or a Honorable Evans Adai or no na eba bema de evidence obema obe yebeto no emana de evidence aba be defend chairman Wontumi and the third witness no or say the name on this witness statement is not one of the names listed in the list of names of witness filed by the accused person. Judge say, but enda yeba court no. Yenim said there are 5 accused people. The 5 witnesses are omo ba be den yeba be cross examine omo. In fact 3 ya cross examine omo wi aka 2. But o see yeba court no. Afa me hwen krate ni ma papa your friend Evans Adai no. Ni dinim. He is one of the people so I also who accused a lawyer and I say who appear could be. You need to make sure he is available. Why say what sabete say nipa we ba be kasa amache ba Wontumi but you be do court in the no sa edine what is going on judge na appear could be die adwuma na wo ye ne sa no because nipa o say obeba betena se me atoto na no ama be protect a defend chairman Wontumi no list ma hwebu nyina menya botra ko CMC, that is the case management conference mako study names are listed the breye say eno sankofo we na wo be from e de o ma betena dakem ema omo se be yatoto ma no a omo defend chairman Wontumi but me do court ya no sa brantie ni di nim die enti na wo yesa. The judge started getting furious because now it say appear could be any chairman Wontumi no omo ya ma dwene say omo person abuse omo go court na nimfi omo person case ni because omo dada court no. And this is something that happens so many times. Oh, and you one day, oh, this is something I appear could be in chairman Wontumi. Yeah. They never spoke about it. The judge did not speak about it. Even the prosecution and the AG never came out to say this is what Apia Kubi is doing in court. There was never a day the Attorney General came out to have a press conference to tell us to say, Apia Kubi mo, to the list but say witnesses way on Bekasa near year from na judge. We never heard the Attorney General make this statement in public. All along, the Attorney General was also focused. The Attorney General allowed the court to deal with these things. But say Attorney General be or pay public sympathy. Or say, I'm for make sense of ejuma. Anka this will be his talking point. Anka this will be his defense. He will be all over the place saying the reason why the case is not done is because Apia Kubi say. The court document is they go and check court proceedings. But the Attorney General did not do anything. Because the Attorney General at that point, his focus was to get witnesses to cross-examine, to get the truth out of witnesses. It will be say, I feel the judge no ya mean. Judge no technically the all can say appear could be a court intro. Appear could be deliberately did the ho and a old court intro. On person be the no or person delay case no. Now young queen. The name on this witness statement is not one of the names listed in the list of names of witnesses filed by the accused person. It is not for nothing that the practice direction on case management provided those direction to be taken. Or see, enyekwa say ye case management conference. The reason tia case management conference and then say send ye beya Attorney General per se or the prosecution witness ba wo apia kubi ubehu nipa kro ubehu omudin ubehu nipa dodo send ye beya wo so apia kubi what the prosecution accused witness ba yes ubehu nipa kro ni din or say enye sa kekenti na CMC butai bi tarechire na sa wo beba court na ya meet na wie na betena court na de adefo fraba means wo no court no person bebu court no it's not judge no to appear could be for say they all you know or say case no nani da ho no obu court na nimtia. He is disrespecting the court like deliberately. Now, already document where a court document, you can go and ask. They will give it to you. Media. Now, say Obesa will follow proceedings, say see court. After this, something happened. The same court. I mean, really, they see in Chiro. They can't be see the attaching so the same strategy appear could be taking and no be no taking the disrespecting of the court, abusing of the court. Say court more opportunity to pay. They will blow it up. Oma MPP lawyers way appear could be an attaching way 2 days. Obe say man could do 2 months. That is why we have to be careful because court you don't allow these things to happen. The moment we give room for that, other criminals, their lawyers or their counsels, that is what they will be doing. Ochina omoko court into you menya abota medwudwa we mu akiro. Now, when you move ahead, this is what it says. The bedrock, I wanted to read this is the latter part of the second one. Change in circumstances to cause a witness to be changed, substituted, and added. It is for the accused person to seek leave of the court, giving reasons for same, and not the situation this court is confronted with presently. Judge Nika say, we are accused, lawyer, who appear to be. Now, so person was a witness, and now open say witness be changing the D, and now we in the D from, and now be for Bishema. You have to follow the right procedure. Unim send ye yen or court ya, but what appear could be a yen say, or Becca say Kevin Taylor and Everton Adakum, Adiabechi, Yabano, not Kwame Amwako, Yabusana, or see when the agenda case in the young Menkorisha Kevin Taylor. Inti Judge Nikachen said that thing now appear could be no good court in the mass, disrespect court no. In fact, court in a chance or the amount say the lawyer for Chama Wontumi, not to me a protector and I said defender no. It is looking like say what is our opportunity no, what the who abuses our opportunity no. It's Judge Niko point to explain to him say, yeah, sir. Adia wo yen enye, wo na wo ma case ni delay because we are not supposed to do these things. What the witnesses list bar also making sure so we diso but to be court now witness list e bia ira obi din nim enti na judge na kire say ye adwuma say court mra no ho wunim dada so obese say obi krampa there is a way you do it, there's a way you go by it, but you just don't appear in court and say me change way without any formal approach to it or formal a way to approach it. It's not judge say no what is going on no who say case no who disrespect the court no who abuse the court no. Now, Momiankoso, Enyanko who de kwesi or court. Now, the bedrock in criminal trials, Judge Nekasano, the bedrock in criminal trials is fair hearing. However, this should not be translated into an abuse. Inti Judge ne say, hey, apia could be nature ma Wontumi ntiasie. Nyoma ma ebebrea mama mo chance sebio mu bu court ne abomfia mo disrespect court no mu delay case no o say saa nyoma na media mama say muntumi emfa nka mo asem no enkyere say mu betumi ebu court ne nimfia ana abomfia mu betuma disrespect court no o say de mi wi kyere say saa na mo pese mo ye o say ye ma obi fair trial Yema obi ho kwan se ono so en defend no ho onfa konfombra be defend no onfa adanse fombra en be defend na se court ma ho kwan na court enya abotre na court anya okeke ya en kire se ubetum the court ni metwitwi fom enti judge ni ka se wo apia kubi wo ne chairman Wontumi ene sa eye the accused person ade a mo ye no emwaye sa nyama we nyina si wo court. Did you ever hear apia kubi come out to say court no be bibi na court na mfa me? Did you ever hear the Attorney General come to say, this is what is happening in court? Appear could be abuse court. No? The Attorney General did not have time for that. The Attorney General's job was to get a witness to cross-examine, was to get to the bottom. If there are there are things happening in court, will be abuse court. Now, it is not for the Attorney General to say. The Attorney General can raise objections and raise concerns in court, but the Attorney General, it is not his duty to make sure, an accused lawyer follows rules and regulations or court proceedings, the regulations. It is the court. Until right now, the judge is talking. The judge is frustrated. The judge has seen, appear could be. Any chairman Wontumi no, almost shut down on person who go court in say, delay case no. Until all the way from May, they started delaying this case. So case where attaching abesomi, nan can you say through June. So case we don't say enter June. Appear could be idea because from day one, not almost strategy. Delay the case, delay the case, delay the case. Now, Judge Nesaka Saya or say the bedrock of criminal trials is fair hearing. Now, at this juncture, Judge Nesaka Muntieno. This is all the way in May. The judge started getting frustrated with Chairman Wontumi Apia Kubi. All the way in May. Now, Judge Nikas will say, at this juncture, the court does not know whether or not the witness statement it has received in the name of Honorable Evans Adai is an addition or a substitution. At a point, now, I feel Apia Kubi a statement for Fraba. I feel that court now confused. Evans Honorable Evans Adai na oka witnesses no. I feel bayani dinim. I feel saba court Apia Kubi akofa sa nipa na no asem de aba say yemfa asem we hye. Like I say, right now dey na wo ye no. List out the brain na ko edi wom. I feel pay court and dinim. Yes, our court was a cover statement. Be able say a aquan statement. The judge say onim say or substitute aquan free case no. So do be beshemo. Right now the judge was confused. I didn't appear could be ye no. I didn't chairman Wontumi appear could be. I saw money dahona on my say on my book or delay case. No. This is May. And remember, before May, no my sign your way be my judge and can be. But you see, anytime they walk out of court, no matter catch you, a case in there, Bibiaboko, judge, they do some time. They knew what they were doing from day one. Deliberate delaying of the case. I idea from day one, not omunim de omuye. Now, when you move forward, judge say, I do not think this sort of practice assists the court in the smooth delivery of justice. TNA, judge say, I do not think this sort of practice assist the court in the smooth delivery of justice. Or say the appear could be woye no. Any the chairman want to moya court. They be no makase, no delay court, no mo. Or say sad the way moye no. Menya sure say mo pese court no. E di juma send you say di juma. I say mo timu pobi say court juma di mo be say no. That is the statement of the judge. So the judge got an idea of what chairman Wontumi any appear could be no moye. And it's on one case no say me who say mo ye bibi say mo pesa mo say case no mo pesa mo delay case no unnecessarily mo pesa mo shada na case we no eye tintia na nipa ehun say de ekọ judge no got frustrated. Remember Adewe has been going on for 5 months. The judge did not say anything, but it got to this point now. Appear could be too much. Appear could be that court no. And you see say judge bia wa body timu poso be di bone na otan chairman Wontumi ka case we can do me. Anka case we no anka say by a match na anka judge no. But you see the judge and the court accommodated all these things. These are documents. These are some of the things they did. Now judge Nicole Nimno, judge Nicole Mokasemi or say CMC, Case Management Conference, is to give direction and clarity to all parties in a matter and above all, avoid surprises. Or say, sa CMC no moye no, a Case Management Conference no, ni nyina say, say yebeko court ochna. Krata bi Attorney General, edeba bebusa eye Chairman Wontumi and the other accused, or say Attorney General be judge in front of eye dey appear could be enim. And as appear could be so, and a baby sebu or better to a year Attorney General witness anwa. I was saying krata or bebusanina or the banner judge no. Send a bear yen quarter or being of a krata be frabontinamba Emma a Attorney General because appear could be krata with the one fan so bebusami witness once them. Or say CMC no Nijuma Diana no. Na ya den yakwa CMC ni ebe bana apia kubi ashada dan no won say the onim say CMC na odin krata foforo nipa din foforo statement foforo o say sa nyoma na apia kubi ye no wa shada. Now uku edima judge this akasa I was saying, so when an accused person in the middle of a trial without leave of the court decided or decides at will to change witness in improper, and this is stated with caution to the accused person, the 1992 Constitution grants rights to all persons, especially in criminal trials. However, these rights should not be exercised in a manner that will degenerate into a pattern of abuse of the rules of court. And a court judge ne kachire eye de o kachire eye apia kubi ene chairman Wontumi say munim bibi de amoye nyina sebio 1992 Constitution eka say nipa bia wo ho kwan say sebio yenka ne kashaboa enhye ne yem obetumi aka na adwene obetumi e defend no ho obetumi afre obi amanaba abeya adansefo amano or say your constitution kire say obia wo ho kwan say sebio obenya fair trial obetumi aka na adwene aka no nokre ma yetie no or say na saa de na ewo ho constitution mu no saa eye tumi na constitution e de ama ye say Ghana for yebetuma fa lawyer yebetuma ko gina court yebetuma ka say oh sebio we de menya hwe nipa we no ho bi we na ma dance for no o say saa tumi na constitution de ma Ghana ni bia no o say opeso o ma apia kubi ene chema Wontumi muti ase say from nyoma o ma ye a o ma hyeda ebu court nim tia ebu eye de constitution nim tia ema apia kubi continuously wa hyeda eye de abuse court no see saa nyoma no sebio o so muti ase say ade bi o ma ya o de ni atofo mehu se e follow pattern bi ade bi ade se utumi tena hu se we ni ade bi o ma form ho adwene se o mo beye o se saa de na den o mo eya abaye o musuban ene o musu no sebio ono oya judge no ohun pen fei se apia kubi ene o mpese obebu court no Chairman Wontumi a oye accused person a wakofa apia kubi no oma bom tirimu po se court no mbebu court nim tia omo de court nim twitwi fom omo be say asem no omo be slow asem no judge na asem o kan no say sanyema amu yi e wo be constitution defend obi but I say he said obi a hu tirimu po de mo ye makama no atum ahwe wa we apia kubi we panyini why a lawyer che but I say why should that sell per se ubu court nim tia me judge ametie me nipa and also me tie obi asem but I say from time ongoing time coming no why say adia why ya no na saa de na wo ye no e kire pefe se wunim de wo ye why adwene say obebu court nim tia. These are judge no words and yet these are not my words. Now judge Nicodemus not say having cautioned accused persons. Now this is what the judge concluded on. Now, court concluded on this. Having cautioned the accused person, so it means the judge actually cautioned Apia Kubi. Cautioned Chairman Wontumi. Said, you are abusing the court. Court na mama fa wodi kakra se mo fandi modwuma no mo pese mo de eden ebu court denim tia. Enti for a judge to caution you, it means the judge has had enough. For a judge to say dia mo ye no muntwa so. Mama mo time too much, and from proceedings you didn't see Apia Stadium Apia Kubi object to it. Apia Kubi never objected to the statement the judge made because no one said they were true, and the judge did not say anything out of what is happening in court. Saying Apia Kubi, the judge Nekano, Tananka judge ni Chatra, Apia Kubi would have objected and say, "My lord, this is not true. I never did this. I never did that. I will never." But you see, because Apia Kubi knew what he was doing. Because Apia Kubi don't him say or person delay case no or person abuse court no or person disrespect judge no or person judge ni bufu na judge de bibi no, he knew what he was doing. Anything a judge no question no said the omo ye no a follow party bi omo njai no, Apia Kubi didn't raise any objection. Now, having cautioned the accused persons, the court will exercise its discretion and adopt the witness and the witness statement as if the witness was listed as one of the witnesses and conduct CMC on same. Inti Apia Kubi, omdisa honorable ada any statement in the baya na at the end of the day, na nkeni say Apia Kubi difa back door dibe court nigga so ni bibi. Apart from all the things you have done, some inconsistencies, abusing of the court still judging say magic in the statement no. Mesa aba CMC. So the judge was not even supposed to do it. Because one, the witness now Apia Kubi edebano. In the first place, where you witness the dear film, and in the second place, the statement to that background, Sebio now witness didn't sign yet, and now the Paul Sanka court, and so judge Nikazoni Bibi. Upon all the disrespect, most show me or court her. Upon all the disrespect, witnesses show me. Upon the things you are deliberately doing to delay the case, still, remember the chance. Come to CMC, that is Case Management Conference, and come show me this new statement you have brought from nowhere, and let the Attorney General be here. I'll be here. I will look at it. I'll give you the opportunity. So you see, upon all the disrespect Apia Kubi show Judge Weno, still the judge gave Apia Kubi that respect. Upon the basic deliberate mistakes he did, they're deliberate. They make it look like it's an oversight. It wasn't an oversight because Judge not judge me for. And Apia Kubi Debi Okacham say, or your experienced lawyer, he knows what he's doing. So the judge knew from day one what Apia Kubi was doing. But you know what? Anka Judge Bianco about the Timu Pose or Tanchema Wontumi that day and Anko be in the case. Yeah. Because those were not Apia Kubi and not Chairman Wontumi, not only witnesses biabim. But you saw what the judge did. The judge said, still, I will give you the opportunity. Remember my chance. Somebody Evans I die we come one. No problem. The statement from nowhere, we don't know where it's coming from. No, I'm going to adjourn my case, meet you at CMC for you to explain to me, for the Attorney General to be there, for we all to understand each other, and come back again and put that person you want to put in the box for cross-examination. The judge still accommodated this guy. The judge on the case still accommodated. You see, in law, you don't allow perception to take over facts. And especially when it comes to criminal cases, when it comes to politically exposed people, when they are standing criminal trial, especially when you have an opposition that can create accusation out of everything. We have people who don't really follow facts. When you're a judge on a case, what you do is you give people the benefit of the doubt. It does not make you weak. It's what it does is that it makes everybody understand out of your courtroom, because and you'll be in a courtroom. What it does is say that leniency, that room you give people you even think are abusing the court. When you do that, what happens is that you make the case more transparent. You don't give people the room to go out there to insinuate, to create an impression, because you see, perception, when it's attached to a crime or a case in court, it basically dissolves the potency of the case. So I think what this judge was doing was that he didn't want to give anybody any room to say the accused person is being treated unfairly. Even though there were some things that this judge was supposed to stop, there were some things this judge was not supposed to entertain. A lot of abuses and disrespect to the judge herself or himself or the court, the judge was not even supposed to allow for some reason, because the judge wanted Ghanaians to understand that this case in court is not personal. She has no personal issues, or he has no personal issue with the Attorney General or even the accused. And that the judge's main focus was to make sure that this case, at the end of the day, whatever the accused has to present, they present it fully. And whatever the prosecution have to present, they present. So the judge was basically avoiding that perception that the accused person is being mistreated, the accused person is being gagged, the accused person's lawyer is not given the room. But you see, the more lenient, the more diplomatically lenient the judge is, the more advantage Apia Kubi and Chairman Wontumi were taking of the court. So you see, now when you give people the room to protect themselves, you give them the room to basically be heard, they abuse it, they take advantage of it. So we are judge and Kaden and Kobe. But all these things happen in court. All these things happen in court. None of us was told about this. But these people are the same people. Right now, what is Atachia doing? Atachia is doing the same thing. But I'll go back to the ruling. About what happened in court. Nobody will accuse anyone of being hard on anyone. And it's all and I will study there. You can see clearly say from day one, Apia Kubi or Shadan or abuse case, or abuse court, and a delay case. Now, shall you see it? Judge Nicasaria, Apia Kubi Ekasaya, what did he say? I have a friend in Canada. He just texted me. He just told me say I should call the witch doctor Kukubunzam. Canada for any Xavier Kukubunzam. Xavier, I'll call you after the show. Now, Judge Nicasaria, Apia Kubi also responded to what the judge said. And then okay. Or say, counsel for A1 and A3, that is Apia Kubi. Or say, we have a witness statement of one Honorable Evans Adae. It was filed on the 28th of May 2026. I pray that the said witness statement be adopted by the court as a witness statement of the said Honorable Evans Adae. So, formally, I feel na all catch the judge and say, sir, witness na. Judge Nico CMC some time back and any dioma Apia Kubi muyi free mono. Afe na Apia Kubi kase afe na the witness no edi ba na statement inti yanko CMC ni yanko discuss biem. So you see, anytime I'm just say if Apia Kubi had an issue with the judge's pronouncement on the delay tactics, on the disrespect and abuse of court, like Apia Kubi be raise an issue and say, Your Honor, or whatever, your lordship, In fact, what you are saying, without due respect, is not true. But you see, Apia Kubi didn't say anything because what he has done, no, on one him na all year, na or abuse court, no. What if the judge did not have that patience, was not professional enough, has no interest in the Obika, just focusing on the case, and like a judge in a react here, according press conference and Apia Kubi Babe. Imagine the judge threw out this their witness statement out to say we have gone to CMC and that we came to court and you're giving us a different thing. Count him the Apia Kubi. Do you know the kind of impression Apia Kubi ni chairman Wontumi they would have come out to put? Count him the Kofi Benton Babakan Obontene. Count him the MPP dogs. You know? Do you know how they were going